27th Congress, 2D Session. Senate. 76, in Senate of the United States. T. the 28th of January, 1842. Ordered to be printed. Mr. Wright submitted the following report: the Committee of Claims, to whom have been referred the petition and par *pus of John Pritchett, report, that the petitioner presents a claim for the expenses of raising and repairing the schooner Henery, of Georgetown, in the year 1814, burnt and sunk under the following circumstances. In the spring of the year 1814, the petitioner, as master and owner of the schooner, shipped at Baltimore, for Washington, 60 barrels of tar, worth, as the petitioner states, $12 per barrel. The vessel sailed from Baltimore with this cargo, which the petitioner says was shipped for his own private account, in the month of May, 1814, and upon the voyage to this city fell in with the United States Flotilla, then upon the waters of the Chesapeake, and under the command of Commodore Barney. A British fleet was then in the bay lower down, and as the petitioner says in great force, and he says Commodore Barney was extremely anxious to prevent said tar from falling into the hands of the enemy's ships, of which they stood in great need, and therefore prevented the petitioner from proceeding with his schooner and cargo, and ordered him to remain under the guns of the flotilla. While the petitioner thus remained, with his vessel, in the company of the fleet, the enemy approached in great force, and compelled Commodore Barney to retreat to the Patuxent, and the Commodore ordered the schooner to take a position in front of the flotilla, so as to keep his armed vessels between her and the enemy. In this form the retreat was continued to the highest navigable point of the Patuxent, while the enemy, in very superior force, made constant close pursuit. The destruction of the retreating fleet by the enemy being thus rendered unavoidable, the Commodore ordered the destruction of the whole, the schooner of the petitioner as well as his flotilla, and the order was immediately executed by firing the vessels. In that way, the schooner was burnt to the water's edge and sunk. During the following year, the petitioner caused the schooner to be raised and repaired, at an expense of little short of $3.00 registered trademark symbol, which expense, together with the loss of his cargo of tar, he states caused his embarrassment and ruin, and that he has never recovered from those losses. For them he now prays indemnity from the government, upon the ground that an officer of the government had taken possession of his property and ordered its destruction, and that it was so destroyed for public purposes. It does not appear from the papers, or from anything the committee can Thorn **Allen, print. 76, to find in relation to the claim, that it was ever presented to Congress, or in any other way that indemnity was demanded or expected from this government, until the spring of the year 1838, during the second session of T. the 25th Congress, and 24 years after the claim, if it be one, occurred. The petitioner makes oath to the truth of the statement contained in his petition, according to the best of his knowledge and belief, but there is nothing found with the papers, from the Commodore or any other officer having command, to show that the schooner was arrested upon her voyage, detained, or destroyed, by his order. John A. Webster, a witness, makes affidavit that he was a sailing master in the flotilla at the time, and confirms, generally, the statements made in the petition. In reference to the arrest of the schooner, and her detention, he uses the following language: in the month of May, of that year, 1814, the schooner Henery, of Georgetown, District of Columbia, John Pritchett master, was brought to by said flotilla, in said Chesapeake Bay, and found to have on board a quantity of tar, then on a voyage from Baltimore to the city of Washington, in the District of Columbia, that Commodore Barney was apprehensive that said schooner, if permitted to proceed on her voyage, would be captured by the enemy's vessels, then not far off, and the cargo on board, consisting of tar, having been reported by Captain Pritchett to be purchased by him for Commodore Tinch, of the Navy Yard at Washington, Commodore Barney was of the opinion that if said vessel was permitted to pass, would be captured by the enemy's vessels, then not far off, and that the cargo of naval stores, or tar, on board, would be applied by the enemy as stores on board his public ships, being an article of which they stood in great need of at that time and sea, and hence ordered the vessel to be arrested on her voyage, and detained, and then the witness gives the same account substantially of her destruction as is given by the petitioner. The deposition of John Peck proves that he was pilot of the Scorpion, one of the vessels of the flotilla at the time, and that he helped to blow up the barges, part of the flotilla, in the Patuxent, under the express order of Commodore Barney, and that the order also embraced the destruction of the schooner Henery, of Georgetown, to prevent the enemy from taking possession of her, but he says nothing of the manner or causes for the arrest and detention of the schooner. John Key now is a third witness, who testifies that he was present at the destruction of the flotilla, and 2 schooners, being a hand attached to one of the barges of the flotilla, that Captain Frazier was, at the time, in command or charge of the said flotilla, and that Captain Frazier was the officer by whose order the flotilla and schooners were destroyed, one of which schooners he says was the Henery, of Georgetown, John Pritchett master. This witness says nothing of the manner or causes for the arrest and detention of the schooner. It is worthy of remark, that neither the petition nor any of the witnesses speak of the destruction of the tar, which composed the cargo of the schooner directly, and the only mention, in any of the papers, from which it can be inferred that compensation for that composes a part of the claim, is that in the petition, stating that 60 barrels of tar, worth $12 each, composed the cargo, and the following sentence in that paper, viz., that, in the following year, 1815, deponent, petitioner, caused said schooner to be unfit and rebuilt, the expense of which was nearly $3,000, which $376, added to the freight and east of her cargo, produced a loss that effectually ruined him, and see accompanying the papers is testimony intended to show, very particularly, the cost of raising and rebuilding the schooner, and a long bill of particulars, of much too general a character for a satisfactory bill of particulars, and with prices of a very extravagant rate where they are specified, in case the character of the charges are properly understood, the whole being footed at $2,913 oil. No testimony is offered to show the fact of the shipment of the tar, its value at the time of the shipment, its destination or object, beyond the statements of the petitioner himself, and no evidence of its destruction, by the burning of the schooner, as before related, is presented. The committee are not familiar with cause and effect in these operations, but it would seem to them that, if 60 barrels of tar, properly stowed in this small schooner, had been burnt by the burning of the vessel, the wreck which would have remained would scarcely have been worth raising for repair, while it would seem quite possible, if the vessel was properly scuttled before she was fired, that her upper works might have been consumed by the fire, as they are represented to have been, in the papers, without injury to this cargo. This remark is made, because they believe it might be worthy of consideration, if the justice of any claim were to be admitted, but in the view they propose to take of the claim, the remark is merely incidental. The committee are not prepared to say they would make the single circumstance of the lapse of time a ground of entire rejection of the claim, but, connected with the other circumstances which are presented in the case, they are not prepared to say a claim is made out at all. The presence of an overpowering enemy's fleet in the waters of the Chesapeake was well known at Baltimore, and over a large extent of the adjacent country, when this schooner left that port for Washington. It was not reasonably to be expected that she could pass round to the mouth of the Potomac without coming under the observation of that vigilant enemy, and she and her cargo would be lawful prize, according to the laws of nations and the laws of war, regardless of what that cargo might consist, or who might be the owner of vessel, or cargo, he being an alien enemy. The cargo actually consisted of naval stores of an important character, and especially to a fleet which had been long at sea, as had that enemy's fleet from the other side of the Atlantic. Indeed, it seems to have come to be well understood on board of our fleet, that the ships of the enemy were in pressing want of this very article, and the committee leave it for the Senate to determine whether that fact would have been likely to be made known to our hostile fleet, before it were in the commercial city from which the schooner took her departure, and where a supply of the article might reasonably be expected to be found. Under these circumstances, this schooner, passing our fleet, and moving directly toward that of the enemy, is, in the language of the principal witness, brought to by the Commodore, and the character of her cargo inquired into. It turns out to be this very article of naval stores of which that hostile fleet was, to use the language of the same witness, in great need at that time. The commander of the schooner reports that he had purchased the tar for Commodore Tinch's, of the Washington Navy Yard, but, so far from producing proof of that fact now, even the allegation is not made by the petitioner himself, but he says in his petition that the cargo was purchased for his own private account, and, under these circumstances, Commo. 86, Fordor Barney does not simply arrest the schooner upon her voyage, but orders her to remain under his guns, and when he can no longer protect her, he orders her destruction, in common with his whole fleet. This is taking the facts as the petitioner states them, and as he labors to prove they are. The committee neither admit nor deny these prominent facts, because neither is material to their present view of the case, though they have already remarked, what they here more particularly notice, that there is no evidence from Commodore Barney to show under what circumstances, or with what views, he arrested this vessel, and forced her not to throw herself in the way of a hostile fleet. There is a discrepancy, too, between the petitioner's own witnesses, two of them, with the petitioner, charging the destruction of the fleet and the schooner to the express order of Commodore Barney himself, and the remaining witness stating, with equal confidence, that Captain Frazier was the officer in command at the time, and who gave the order for the destruction of all the vessels. This would have been a matter most easily settled at the time, or within any reasonable period after the transaction, as both Commodore Barney and the petitioner were residents of the same section of the Union, and the former lived, for more than 4 years, in the vicinity of the very waters upon which the tuna sailed upon this voyage, and upon which the papers show she continued to sail up to a period later than the year 1829. In any event, under these circumstances, the claim has been permitted to leap until the death of the Commodore had drawn the silence of the grave over his testimony, and he lived for a sufficient time after the transactions to have made him, not simply a conclusive, but a convenient witness, in point of location and residence, for the petitioner. Of Captain Frazier, and the other officers in commission and command in the flotilla, the committee have not sought information. It is enough for them that the petitioner has not thought best to seek them out, and procure their testimony, and they find no inducement to call upon them to disprove the claim as now presented. Without however attempting to impute unfairness of intention to the petitioner, in the voyage he sets forth, or in the selection of the cargo for that voyage, and assuming the interference of Commodore Barney to have been what he alleges it was, does he make out a case of injury to himself thereby? If his vessel and cargo had fallen into the hands of the enemy, in the regular prosecution of his voyage, does anyone suppose they would have been treated with patriotic fairness on his part, in any other way than as lawful prize, which would have deprived him entirely of pecuniary benefit from both, exclusive of his own fate and that of his crew, as prisoners of war? If the same thing had happened at the place of destination, would he have been better that his schooner and cargo were delivered into the hands of a victorious enemy uninjured, than that the vessel was sunk, and her upper works burned to the water's edge, in the upper waters of the Patuxent, thus leaving the hull, to say nothing of the cargo, to be raised and repaired in the following spring, so as to be a vessel navigating the same waters for which she was originally destined, up to the year 1829 at least, full 15 years after her partial destruction. The committee can form no such conclusions from the facts and premises here presented, and they therefore respectfully submit to the Senate, and recommend for its adoption, the following resolution: resolved, that the prayer of the petitioner ought not to be granted,